Good afternoon, everybody. Bill O'Leary coming to you on this Thursday. And I'm coming to you live as part of our Thirsty Thursday series. So I'm a lawyer at Legacy Planning Law Group, estate planning, elder law, probate, estate and trust administration. And what I do for those maybe stumbling across me for the first time is um, I come live every Thursday to talk about a different sort of estate planning, elder law topic that I sort of catches my interest in the past week. So if you're thirsting for knowledge, you've come to the right place. Today's topic is a tax topic, tax consequences of selling a house after the death of a spouse. What are the tax implications of that? So if your spouse dies, you may have to decide, as maybe the surviving spouse, whether to sell the house, and if so, when to sell the house. And there's some tax considerations that go into that decision. The biggest concern when selling a property, whether it's a house or other real estate, is capital gains taxes. Now, a capital gain, let me explain, is the difference between what's known as the basis in property and then what you sell it for. And the basis basically represents your investment in the property. Usually it's what you paid for, it's your original purchase price. So let's say you bought a home for $250,000 and then you later sell it for $450,000. Well, you have a gain of $200,000. The $450 that you sold it for minus the $250 that you bought it for. That's $200,000 of gain, capital gain. Now, couples who are married and let's say they file taxes jointly, they can sell their main residence and they can exclude under the tax code up to $500,000 of the gain from a sale of the house. They're going to exclude that gain from their income. Now, a single person doesn't get the $500,000 exclusion. They just get half of that, $250,000. So let's say that you bought a house for $200,000, you sell it for $400,000, and you're an individual person. You have $200,000 of gain, but there's no tax on that because the first $250,000 basically is free. Now, surviving spouses, even though we have one spouse left at that point, they can still get the full $500,000 exclusion if they sell the house within 2 years of the date that their spouse died. And if also there's some other ownership and use requirements that are met under the tax law. The result is that widows and widowers who sell the property within 2 years may not have to pay any capital gains tax on the sale of the home. Again, it all depends on what was paid for it and what it's sold for. Now, if it's been more than 2 years after the spouse's death, the surviving spouse can exclude only $250,000 of gain. So there's an incentive to sell the house within that 2 year period to get $500,000 of exclusion. If the surviving spouse waits 2 years and 1 day, only gets $250,000 of the exclusion. Now, the surviving spouse does not owe taxes automatically on the rest of any gain. So, now when a property owner dies, the cost basis of the property, when they die, the cost basis of the property that they own is stepped up. This means the current value of the property becomes the new basis. When a joint owner dies, half of the value of the property is stepped up. So, for example, let's say suppose a husband and wife together buy a property for $200,000 in this example. And then the husband dies, and when he dies, the property has a market value of $300,000. So it went up $100,000, okay? 200 to 300. You with me? Now, the new cost basis of the property for the wife, what is that going to be, okay? Is that the $300,000 that it was worth? Well, no, not quite. It's only going to be that new basis for the wife is going to be $250,000. How did we get there? Well, it's based on $100,000 for the wife's original 50% ownership in the property, and then another $150,000 for the other half that passed to the wife at the husband's death. So that's what would happen in Florida. If by chance you live in another state that is known as what's called a community property state, and those are states like we've got Arizona, California, Idaho, Nevada, New Mexico, Texas, Washington, Wisconsin. I think I've listed all of the community property states. There, If property is acquired during the marriage, it's considered community property of both spouses, and at the first spouse's death, you get a complete 100% step up in the basis. So if you'd like to know more about what the tax consequences are of selling a home after the death of a spouse, and how we maybe can help you, we'd love to talk to you. So we invite you to book a free 15-minute discovery phone call, okay? Just go to our website, Legacy Planning Law Group, legacyplanninglawgroup.com. Find the blue button on the homepage. It's called Book Your Free Call. Click on that, takes you straight to our booking calendar. Pick a day and time that works for you, and it's a chance for us to really start a conversation. So if you've enjoyed this video, I would ask that you like it, better yet, to really sort of get the word out even more effectively. If you could share the video, I'd be indebted to you. So I hope you've enjoyed this talk, the tax consequences of selling a house after the death of a spouse. I'm going to give another talk next week, next Thursday, about this same time, part of our Thirsty Thursday series. So if you're thirsting for knowledge, we will quench your thirst. So Bill O'Leary, signing off for now on behalf of everybody here at Team Legacy. Go make it a great day and make it a better world.